Time to confer with Mr. Soto-Escalera. Any further evidence from the defense?
Well, Judge, I did have some commentary to make and some argument to make. However,
Right. But outside of argument,
no more. Well, Mr. Soto-Escalera wants to speak, Judge. I do believe.
okay.
My client would like to address.
Okay, he may make a statement either under oath or not under oath at his choosing, allocution or otherwise.
It's allocated.
Okay, you may make a statement, Mr. Soto-Escalera, at this time. Go ahead.
Thank you, sir. What I'm bringing to the courts to address is, I have a conflict of interest. Mr. Thomas Burns. So I was asking for your permission, if it's possible, if I can get him removed from my case, because I don't trust him.
Mr. Soto-Escalera, trying to think of how to say this in a way that's most understandable. I think there's an expression, we're at the 11th hour. This is probably even beyond that. We're probably at about 11:59 here. We're about to close all of the evidence in your case, which would be submitted to me with the jury's recommendation, whether you should receive the death penalty or life in prison. Counsel has already done his job. They've already completed their work on the case. Really, at this point, all that's left for them to do is argue to me. So I don't believe there's really any purpose in that at this time. Even if I were to grant your request, there's nothing left for counsel to do at this time other than to make argument to me, which quite frankly could be persuasive, but given the judge's function and where we are, as I mentioned, 11:59 metaphorically, there's really not much purpose in that. So from counsel, since it does affect counsel, does counsel agree with my observation on that particular point? I'm going to inquire Mr. Soto-Escalera whether he wants to speak about the decision I have to make and give me input in that regard, because he has the right to do that. But that's separate and apart from what's being said now. Does counsel for the defense agree with my observation as far as, if this is a request to discharge counsel, where
Absolutely, Judge, and
the
that
horse is out of the barn at 11:59 p.m., I suppose would be the metaphorical.
correct. And as I explained to my client, I am not qualified to be on the case by myself because I'm only second share qualified. So Mr. Burns has to remain on the case to the duration.
Right, and just for the record, I haven't heard the arguments yet, but there's been a substantial amount of mitigation put before me, both at the trial and additionally here today, that I have to consider and digest. And does not seem to me that there's any reason for me to discharge counsel at this time. More importantly, before you brought that up, Mr. Soto-Escalera, you do have the right to make a statement at this time, either under oath or otherwise, that I would consider in making my determination in this sentencing proceeding. You understand you have that right to do that. And I was assuming that you were going to do that. I'm not saying whether you should or not. That's between you and your counsel. But I want to make sure that by me dismissing your conflict of interest issue, you don't take that as me dismissing your ability to make such a statement. Do you wish to make such a statement, or do you wish to talk to your counsel about whether you wish to do that at this time?
The only reason why I brought it up, Your Honor, is because something has surfaced with a witness and it was recorded in audio. This is why I'm requesting that I would have him removed. But if I can't remove him, I would like you to see what I'm speaking about so you can understand what I'm trying to say, if you have the time.
With regard to that, that would be a decision in this very important context for your attorneys to make, whether to submit that issue to me as far as potential mitigation. And as I'm required to do, I would defer to their professional decision in that regard.
Enough, Judge. I'm going to lay it all out on the record, okay? I think Mr. Soto-Escalera is hurting his situation. He's proceeding in ignorance on the advice of ignorant people. What he is referring to is a Zoom recorded deposition. The first such deposition I ever did in my life. We witnessed Lucinda Cook. This was done, I think, on a Tuesday when it was a court holiday, when we were in the midst of trial or jury selection. I'm not sure exactly where we were yet. And before Ms. Cook joined, there was a recording with chit chat between me and Mr. Richardson about witnesses in the case, about the state of the case, about why I was calling witnesses and not calling witnesses, and complaining about somebody who had Ms. Minton's credit card and was going over the limits, and chit-chatting as counsel do between themselves, waiting for a witness. And I don't think people understand the context of how attorneys talk to each other. I think that the witnesses who overheard this, Ms. Lucinda Cook and whoever else she communicated with, think that because this is a capital murder case, me and Mr. Richardson should be like this with our hands around each other's throats every moment. And we were not that way. We were chatting as counsel do in a case. And in a capital case especially, do counsel and adversaries have to communicate frequently and exhaustively to get the thing from start to finish done. That's all that it was. There is nothing in there that was inimical to Mr. Jose Soto-Escalera's defense, and I defy him or anyone else to point to any action or anything that I did or said at any point in the preparation of this case or in the trial or in the penalty phase that was contrary to his interest. It's nonsense and bullcrap, and that's what he's on about, Judge. So he can feel however he wants. He's an idiot on this issue, at least.
In that regard, for Mr. Soto-Escalera's benefit, the people who are here observing this proceeding, regardless of the court's sentencing decision, whether I impose a life sentence